Now, this particular case started with an indictment from Mr. Trump regarding his actions on and around January 6th. A federal grand jury indicted former President Donald J. Trump on 4 counts for conduct that occurred during his presidency following the November 2020 election. The indictment alleged that after losing that election, Trump conspired to overturn it by spreading knowingly false claims of election fraud to obstruct the collecting, counting, and certifying of the election results. Trump moved to dismiss the indictment based on presidential immunity, an argument that a president has absolute immunity from criminal prosecution for actions performed within the outer perimeter of his official responsibilities, and that the indictment's allegations fell within the core of his official duties. The district court denied Trump's motion to dismiss, holding that former presidents do not possess federal criminal immunity for any acts. The D.C. Circuit affirmed. Both the district court and D.C. Circuit declined to decide whether the indicted conduct involved official acts. Trump says he has immunity. The district and circuit courts disagreed. However, the Supreme Court did not. Held, under our constitutional structure of separated powers, the nature of the presidential power entitles a former president to absolute immunity for criminal prosecution for actions within his conclusive and preclusive constitutional authority, and he is entitled to at least presumptive immunity from prosecution for all of his official acts. There is no immunity for unofficial acts. The court based its decision on the doctrine of separation of powers. Under the Constitution, each of the 3 branches of government are given specific powers which only they can exercise. The court expanded on this in their opinion. This case is the first criminal prosecution in our nation's history of a former president for actions taken during his presidency. Determining whether and under what circumstances such a prosecution may proceed requires a careful assessment of the scope of presidential power under the Constitution. The nature of that power requires that a former president have some immunity from criminal prosecution for official acts during his tenure as office. At least with respect to the president's exercise of his core constitutional powers, this immunity must be absolute. As for his remaining official actions, he is entitled to at least presumptive immunity. Interesting that the court claims immunity is a question of separation of powers because the court ignores the fact that the powers are vested in the office, not the person holding it at any point in time. This is an historic case, not simply because a former president is accused, but the circumstances under which he was indicted. Let's start with whether or not such a prosecution should move forward. Article 2 of the Constitution vests executive power in a President of the United States. The President has duties of unrivaled gravity and breadth. The Constitution does vest the executive power of the United States in its President, but the duties that Constitution vests are not unrivaled in gravity or in breadth. For example, the President is the Commander-in-Chief of the Army and Navy, Article 2, Section 2, Clause 1. But it is Congress that sets the rules for the military, Article 1, Section 8, Clause 14. The President can sign treaties and make appointments, but only with the advice and consent of the Senate, Article 2, Section 2, Clause 1. Notice, this court points to the Constitution for the President's executive power, but to another court when discussing its gravity and breadth. His authority to act necessarily stems either from an act of Congress or from the Constitution itself. In the latter case, the President's authority is sometimes conclusive and preclusive. When the President exercises such authority, Congress cannot act on and courts cannot examine the President's actions. It follows that an act of Congress, either a specific one targeted at the President or a generally applicable one, may not criminalize the President's actions within his exclusive constitutional power. Neither may the court adjudicate a criminal prosecution that examines such presidential actions. The court thus concludes that the President is absolutely immune from criminal prosecution for conduct within his exclusive sphere of constitutional authority. This is where I see the court drifting from its constitutional power. Yes, the President's power comes from the Constitution, but nowhere in the Constitution is Congress delegated the power to grant him authorities other than his constitutional ones. The court appears to try to split the baby between official acts that are within his constitutional power and those that are not. Not all the President's official acts fall within his conclusive and preclusive authority. The reasons that justify the President's absolute immunity from criminal prosecution for from acts within the scope of his exclusive constitutional authority do not extend to conduct in areas where his authority is shared with Congress. To determine the president's immunity in this context, the court looks primarily to the framers' design of the presidency within the separation of powers, precedent on presidential immunity in the civil context, and criminal cases where a president resisted prosecutorial demands for documents. Do you see the contradiction? The court talks about separation of powers while claiming there are powers shared with Congress. Are the powers separate or not? When the court looks at the framers' design of the presidency, it appears their view is myopic, as the dissent pointed out. In the Constitutional Convention, James Madison, who was aware that some state constitutions provided governors immunity, proposed that the convention consider what privileges ought to be allowed to the executive. Now, there is no record of any such discussion. Delegate Charles Pinckney later explained that the convention which formed the Constitution well knew that no subject had been more abused than privilege, and so it determined to limit privilege to what was necessary and no more. No privilege was intended for the executive. Other commentators around the time of the founding observed that federal officials had no immunity from prosecution, drawing no exception for the president. James Wilson recognized that federal officers who use their official powers to commit crimes may be tried by their country, and if their criminality is established, the law will punish. A grand jury may present, a petty jury may convict, and the judges will pronounce the punishment. A few decades later, Justice Story evinced the same understanding. He explained that when a federal official commits a crime in office, it is indispensable that provision should be made that the common tribunals of justice should be at liberty to entertain jurisdiction of the offense for the purpose of inflicting the common punishment applicable to unofficial offenders. Without a criminal trial, he explained, the grossest official offenders might escape without any substantial punishment, even for crimes which would subject their fellow citizens to capital punishment. This historical evidence reinforces that, from the very beginning, the presumption in this nation has always been that no man is free to flout the criminal law. Now, contrary to the court's opinion, not only is presidential immunity not included in the Constitution, but apparently the idea of privilege was rejected during the convention. The evidence shows that the idea of immunity for an office was downright offensive to those who drafted and commented on the Constitution. The court went on to explain their position. The framers designed the presidency to provide for a vigorous and energetic executive. They vested the president with supervisory and policy responsibilities of utmost discretion and sensitivity. Appreciating the unique risks that arise when the president's energies are diverted by proceedings that might render him unduly cautious in the discharge of his official duties, the court has recognized presidential immunities and privileges rooted in the constitutional tradition of the separation of powers and supported by our history. In Fitzgerald, for instance, the court concluded that a former president is entitled to absolute immunity from damages liability for acts within the outer perimeter of his official responsibility. The court's dominant concern was to avoid diversion of the president's attention during the decision-making process caused by needless worry as to the possibility of damages actions stemming from any particular official decision. Once again, we see that the courts, not the Constitution, are the source of this idea of presidential immunity. Yes, we want an executive that's energetic in exercising his duty, but how far does that go? If we look at the context of Federalist 70, we find Alexander Hamilton was asking the same question. Taking it for granted, therefore, that all men of sense will agree in the necessity of an energetic executive, it will only remain to inquire, what are the ingredients which constitute this energy? How far can they be combined with those of other ingredients which constitute safety in the Republican sense? And how far does this combination characterize the plan which has been reported by the convention? The court seemed very concerned about the prospect of impairing the president's ability to act, but not the dangers of a lack of restraint. The court's dominant concern was to avoid diversion of the president's attention during the decision-making process caused by needless worry as to the possibility of damages actions stemming from any particular official decision. What about the consideration of the consequences of the president's action? Shouldn't someone with the powers of the president consider the legality of their actions? Is there not a need to worry about the impact of one's actions, especially if those actions are criminal? Shouldn't the court's dominant concern be about the application of the law rather than covering over the bad decisions of the president? Taking into account these compelling considerations, we conclude that the separation of powers principle explicated in our precedent necessitates at least a presumptive immunity for criminal prosecutions for a president's acts within the outer perimeter of official responsibility. Such an immunity is required to safeguard the independence and effective functioning of the executive branch and to enable the president to carry out his constitutional duties without undue caution. The court has yet to provide a constitutional argument of how the separation of powers places anyone's actions above review. What this court has done is promote the opinion of previous judges, unsupported by law or constitution, above the supreme law of the land, and created a privilege for the president that was not only rejected by the Federal Convention, but by those who observed and commented on it. The essence of immunity is its possessor's entitlement not to have to answer for his conduct. Presidents, therefore, cannot be indicted based on conduct for which they are immune from prosecution. As we have explained, the indictment here alleges at least some such conduct. The court never answers what appears to be the most important question. How can we know if a president's conduct is immune from prosecution if the deciders of facts, the courts, are not allowed to look? The court's position not only creates a self-fulfilling prophecy, but an active immunization of any president for his actions while in office. If a president cannot be held to answer for his conduct, how can that be considered anything but placing the office above the law? The court even admits that their position is not based on the Constitution. True, there is no presidential immunity clause in the Constitution, but there's no separation of powers clause either. True, the phrase separation of powers does not exist in the Constitution, but the principle is clearly spelled out in the first clause of the first three articles. All legislative power herein granted shall be vested in a Congress of the United States. The executive power shall be vested in a President of the United States. And the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. Each branch is vested with specific and separate powers, hence the separation of powers. But those powers are vested in offices, not the people in them. Furthermore, Article 3 not only vests the judicial power of the United States, it sets their jurisdiction as well. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority. How can the court have jurisdiction in all cases in law and equity if this court exempts the president from said jurisdiction? The court's opinion dealt with several of the dissent's arguments. One, however, I think is worth discussing here. The principal dissent then cites the impeachment judgment clause, arguing that it clearly contemplates that a former president may be subject to criminal prosecution. But that clause does not indicate whether a former president may, consistent with the separation of powers, be prosecuted for his official conduct in particular. As the court points out, the impeachment judgment clause does not prohibit criminal prosecution after conviction, but neither does it prohibit prosecution without impeachment. In fact, the impeachment judgment clause specifies the judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to the law. If the impeachment judgment clause states that a president can be subject to trial after impeachment, how can the court claim he's immune from answering for such crimes? This court claimed that any such action would be outside of the president's official duties, but that doesn't make sense, as the dissent points out. When he uses his official powers in any way under the majority's reasoning, he now will be insulated from criminal prosecution. Orders the Navy SEAL Team 6 to assassinate a political rival? Immune. Organizes a military coup to hold on to power? Immune. Takes a bribe in exchange for pardon? Immune. All of these actions, and plenty more, are part of the core official powers of the president and expressly illegal.